Welcome to Paradigm Shifts, new thinking about our changing times with your host, Harriette M. Steinberg, practicing matrimonial and family law, real estate, trust and estates, and elder law. You can watch episodes on YouTube and listen through Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. For prior episodes, go to www.lawyersonli.com. Now here's the host of Paradigm Shifts, Harriette Steinberg.
Welcome to another episode of Paradigm Shifts. I'm Harriette Steinberg, also known as the Divorce Sherpa. I'm an attorney and I practice in the areas of matrimonial law, estates and trusts, elder law, and estate drafting. Well, today our guest is Neil Cahn. Neil has been a matrimonial practitioner for about 40 years. He is a litigator, a collaborative divorce attorney, and a mediator. And for more than 40 years, I must tell you, I'm going to be reading a little blurb from Neil's bio because I can't do any better than to read what is here. For more than 40 years, he has represented clients in complex divorce custody, support, and property trials. He has argued appeals to New York's highest court and served as a collaborative divorce counsel and as a mediator. He has drafted prenuptial, postnuptial, separation, divorce settlements, and post-divorce agreements, from simple to the highly complex. Neil, I don't know what else I can add to that 40 years of experience, but I think we can let everybody now judge for themselves. So welcome.
Good morning, Harriette.
Yeah. So Neil, here's the question of the day. What has your paradigm shift been in the world of matrimonial law?
Well, after, say, the first 25 years of litigating and having that litigator's hat on all the time, about 25 years ago, I became certified as a mediator and learned a different way to do things, a different way to listen to people. Active listening was a skill that I needed to improve. Lawyers love to do their own talking. Sometimes it's very hard for them to do the listening. And after 5 years of working as a certified mediator, I became familiar and started to become active in collaborative divorce. And for the past 15 years, both you and I, Harriette, have been very active in promoting collaborative divorce, as well as mediation and doing litigation. And I think you and I have worked together long enough to know that we believe that there's a far better way to transition a family from intact to post-divorce than an adversarial system of litigation. So the paradigm shift for me has been to recognize that I can't and shouldn't be wearing that litigator's hat all the time. If I want to best transition a couple from intact to post-divorce, I should use a process that helps them do that transitioning. And I have to remove myself from the adversarial process and engage them in helping them communicate with each other and resolve their conflict themselves as best as they are able.
Yeah, I think that is well said, but, and I would say not but, and I know for me, the challenge is always trying to explain this concept and the benefits of this transitional process to clients. Don't you find that often mindsets are sort of fixed when.
More, I'm sorry, Harriet.
No, go ahead.
Absolutely. Um, 25 years ago, mediation wasn't as popular. Uh, Collaborative divorce essentially on Long Island was unheard of. And when a client would come in to the office, the client would expect them to be meeting their warrior, their advocate. All right. Now, mediation is more popular, collaborative divorce is being heard of. So they're open to the process of trying to work with an attorney on different ways of getting to the divorce process. So now, part of my job, if I'm going to present a client with the alternative methods of divorcing, is to let them know that I can serve as their counsel, but it doesn't have to be in an adversarial process. If I can meet collaborative counterparts and work both with them, but at the same time properly representing my own client, it's the best of all worlds. And sometimes during that process, clients are a little taken aback as I listen to the other spouse or the other partner. It's new for them. It's new for us. All right. And you and I know, Harriet, that for the past 15 plus years, we've been working very hard at our own paradigm shifts, as well as teaching others to do it as well.
Yeah, I think that's an important point that we really need to focus a few moments on. Getting ourselves into the paradigm shift and the thinking and the validation of our approach has been a constant learning experience for me, as well as I know, Neil, for you, and that is, in my mind, one of the beauties of our practice of being a collaborative attorney in this field. As the more we do, the more you begin to realize that it is the journey, the way you take the journey or make the journey, that is a fundamental part of the work we do. Wouldn't you say?
You're absolutely right. And engaging in active listening, both to collaborative counterparts, my own client, the other party, both in collaborative divorce, but as well as serving as a neutral, as a mediator, to listen to both. People have said to me that I have become a different person.
Well, that's true. I will be the first one to say that. Yes.
I must tell you that my wife has remarked that I have become, while being able to continue to litigate, I'm also able to better listen, and then to a certain extent show a softer side, or at least a more participatory side.
Yeah, and in fact, it's amazing when you think about that, because you've had that. It's been part of who you are all the time. But as a litigator in the adversarial system, none of us could see that, and frankly, I think our processes are richer by having this element in the way we work. And it is this process, the process of active listening and meeting each of the clients and where they are and what they need, that clients get from collaborative process. And in my opinion, you can't put a dollar value on the benefit of that process. And
You're absolutely right about that. When, as a litigator for the first 25 years or so, at every stage, in drafting every single piece of paper, you're out to win. That's your job. And sometimes if you are promoting your own client, you have to denigrate the other side. All right. When you move into mediation and collaborative divorce, that's not your priority. You do want to best serve your client, but you don't do it where every word out of your mouth is an effort to win. Here, it's an effort to bring the parties into an agreement that will help them move forward in their lives, and to do it with the least damage, both emotional, financial, in every aspect of their lives. You don't want the process of the divorce to further compound the damages and pain that they've already suffered. And needless to say, you and I both know how important this is for their children. The parties, the children use their parents as role models, and if they see them able to work together to resolve conflict, all right, continue, if not better, to communicate with each other and be able to move forward without the extreme bitterness that a contested divorce can bring with you. That is something that will help the children for the rest of their lives, and also enable both parties to be able to enjoy the lives of their children. There's nothing worse than with the first grandchild, one parent is not allowed to come to the first birthday party, all right, because that bitterness carries on for decades. And therefore, whenever we do a mediation or a collaborative, but it's also filtering into the way litigation is approached and the concerns of the court. We're looking to promote the benefits to the children as well as to the parties themselves. They need to heal, and in healing them, you are benefiting their children.
So would you, in terms of a paradigm shift from the time, I know you and I both went to Hofstra Law School, from the time we started to practice and to today, are you seeing any shift in the litigational arena in terms of at least recognizing the futility of, not the futility, but the benefits, I should say, of working in an ADR arena?
Oh, absolutely. But it's also, but you're absolutely right. The paradigm shift also occurred as early as law school. When I went to law school, ADR was not on the menu.
Right.
You learned substantive law, you learned trial techniques, okay, but it was teaching you to engage in the adversarial system. As the public has learned that mediation or collaborative is a different, an alternative dispute resolution process that can best help them and meet others of their goals, the law schools are training as well. And fortunately, one of the things I enjoy the most is I have, for many years, been brought into family law skills courses and worked with law students at Hofstra Law under Professor Shepard. And you do see the impact in the courtroom, even in litigation, primarily among the lawyers who have had the opportunity to experience both processes, of both alternative and litigation. Every once in a while, you get a lawyer who hasn't had that experience, who is out to litigate, who is out to win, who is out to crush, and you have to respond to it. But fortunately, by this time, most of the lawyers, Harriette, that you and I know who practice family law have become experienced enough to know there's a better way. Generally speaking, you and I, when we meet a client, have a really good idea of where the case is going to end up. Yeah. We just need everybody else to catch up to that. Yeah. The process has to run its course. The parties have to be, I call it seasoning. They have to be ready to accept it. They have to learn to accept it. They have to understand it. All right. But especially if you're dealing with a lawyer that you've worked with in a collaborative setting for years, Okay, Harriet, you and I know we trust each other implicitly. All
Yes.
right. We respect each other. We know we're going to be looking to promote the interests of our own client, but we're going to do it in a way that you can count on me to be honest and trustworthy and work with you to find a good solution for both parties and to move them forward properly.
And these are the intangibles that are worth so much in terms of the overall experience for a client. And what I know we share the goal of disseminating this, trying to let people know that the process that we would prefer to work in with people is this collaborative process, because ultimately they end up in a much better place than not having this enrichment. It's like often we've had cases where we've had one client who's already at the finish line. They've worked through their grieving process. They've come to the conclusion the marriage is over. And we have the other partner who is just in the beginning, who sort of comes to the table not knowing what is happening to their life. Can you talk to that? I know we've had it, so how do you see our process supporting the growth that the clients need to experience?
Very often, especially under the old format, a client comes in wanting to punish their spouse.
Ah, yes.
And it takes a while, no matter what process we're using, to let them realize that the court system doesn't exist to help them punish their spouse. It's not what it's about. New York, over the last 10, 20, 30 years, has been moving forward, bringing in no-fault divorce. We were the last state to do it. But the courthouse is not going to be the process for somebody to pat you on the back and say, you were the better spouse. You're not going to be able to punish the other spouse. You're not going to be able to be told you're right. You were right. You don't deserve this. That sitting around the collaborative table, we can do that. It's our goal to do that faster and better. It's why we often bring in, as a member of the team, the collaborative team, a mental health professional to watch out for hot button issues. But in my particular experience, I've had several cases where it happens to be the wives, where they were actually unable to communicate with their husband. They could not have a conversation about finances. They were completely intimidated. And part of the process with both counsel, with the mental health professional, the family specialist, is to help the weaker spouse develop their communication skills so that the two of them can work together to find their financial issues, their parenting issues, and move forward. When that happens, okay, the weaker spouse in that case, or the one who wants to punish, gets the chance to be seasoned, to be ready. All right, but it can happen a lot faster from the very first meeting. Okay, everybody, all the professionals are working to enhance the parties' ability to communicate with each other, to bring them forward emotionally, to help them work out a resolution that's best for them, and to move forward out of the marital situation to a much better life for themselves, for their children.
When I hear you describe our process this way, I sort of want to get on a mountain and just shout to everyone, stop litigating, stop looking to go to court. We have the better process. But I guess that's going to be our work for the next years as we go forward, convincing people that this process ultimately enriches their lives, their future lives, even though a family is disorganizing and reorganizing in a different way. Would you agree to that?
Oh,
idea? Yeah.
absolutely. The opportunity, there is a lot of, now that you hear more and more podcasts, more and more psychological programs, okay, on how much forgiveness helps the forgiver, okay? The combination of working through those emotions, working through the hurt, working through the anger at the table with both parties present, with their conversations being facilitated by both the lawyers, the family specialists, even the neutral financial people that we use, so that people become more informed and can better talk with each other. Every single step, literally, almost every single word that the parties say are being listened to with an eye. One role we're doing is, what can we do to have that thought of a party move them forward to a better result? All right.
So, Neil, can you, before we go, because I think we could be here all day talking about collaborative practice and ADR and the paradigm shifts, tell us what's the best way to reach out to you, to engage or consult with you?
Thank you for that invitation.
Yes.
I do have an internet presence. I've had a blog on New York State case law for a dozen years that I very much enjoy writing, and that has been very well received. That blog is www.divorceny.com. I also have my personal firm website. That's at Cahn, C-A-H-N, my last name, .law, not com, but Cahn.law. You can Google me, and that'll get you to here with a phone call, an email, a text. I'm easy to find. Harriet, you know, we both try to make ourselves easy to find.
Yep, that's true. Neil, I really appreciate your visit today. It's been enlightening, enjoyable, and here's to working more years in collaborative practice. Thank you.
Thank you, Harriet, very much.
Thank you for listening to Paradigm Shifts, new thinking about our changing times, with your host, Harriette M. Steinberg, practicing matrimonial and family law, real estate, trust and estates, and elder law. You can watch episodes on YouTube and listen to Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. For prior episodes, go to www.lawyersonli.com.